Ma'am, are you there?
Yes.
Right. Okay. A very good evening to all present here. We have with us today on our second day of orientation to deliver the commencement address an extremely distinguished personality, Ms. Indira Jaising. She is a senior advocate at the Supreme Court of India who is noted for her legal activism in promoting human rights causes and social justice. In 2018, she was ranked 20th in the list of 50 greatest leaders of the world by Fortune magazine. She's co-founded the Lawyers Collective, a legal NGO that has been working since 1980 for the rights of the marginalized, particularly women, LGBTQI individuals, sex workers, and many more economically and socially disadvantaged groups. She was pioneering in informing landmark laws against domestic violence, against sexual harassment at workplace, among other legal interventions. I do not have enough words to describe an accomplished personality like her. On a more personal level, while interning at the Supreme Court with Justice Deepak Mishra, I have seen her very closely argue the 2G spectrum case very passionately. As a law teacher at NLSIU University, I have seen her take on the mighty academician, Professor Madhav Menon, during a lecture series, where she wholeheartedly stood by her convictions and values. All I can say is that I am in awe of her, a woman who is an epitome of empathy, of hard work and grit. Yesterday, when the incoming students, both BLLB and LLM students, they asked us questions curiously, what is our expectations from them? What are the qualities of a good law student? Who should they idolize and be like? Confidently, I'd say like Indira Jaising. We welcome you, ma'am. Please share your insights with us and speak about your love for the law. We will have a question and answer session post her talk. Please put in your questions in the chat box below and I will take them up. Now I'd request the registrar, Professor Nigam Nogihali, to please say a few words welcoming Ms. Indira Jaising.
Thank you. Thank you, Prerna. I am delighted to welcome Ms. Indira Jaising. Like many students here today, I was once a student at the National Law School, Bangalore, during its early years. I was the 5th batch. And both during our conferences during that time, as well as the law reform projects that law students used to do at that point of time, we took guidance and inspiration from the work of Ms. Indira Jaising. And right throughout after that, through my career as a practitioner of law and as an academic, I have very closely followed Ms. Jaising's work, and I'm in awe of the fact that she's able to combine her excellent work and track record in the law with her deep interest in the protection of human rights and the protection of marginalized communities. I think this particular talk will be really useful for our incoming students because they need to understand why law is considered as a noble profession and why it can make a huge and decisive difference in the lives of marginalized communities. Sometimes some of our students tend to take a very transactional view of law, and it's important, therefore, that they listen to someone who has had a deep interest in law as a constitutive phenomenon in alleviating the suffering of a fellow countryman and in trying to figure out how law can make a difference in the lives of our citizens. So on that note, I welcome Ms. Jaising, and I'm sure we're going to have a grand time listening to her. Thank you.
Can you hear me?
Yes.
Yes, we can.
Okay. So may I start?
Yes, please.
Okay. Thank you for the extremely kind words spoken by both of you today. And if for no other reason, that would be sufficient reward for me to be with you today. But of course, the real reward is the opportunity to talk to really young people. I emphasize the word young because I have been in the profession for over 50 years now. And when I was asked to recall my student years, I was tempted to say, I have almost forgotten. But that is not the truth. I do remember my student years. But I do not want to talk to you about my student years. I would like to talk to you instead about the world that you are stepping into and the world that you will step out of once you leave this really wonderful university. Of course, all of you know that you are privileged to be in a university of this kind, and therefore it is your obligation to make the most of what you can in these years ahead of you. So let me begin by saying that as you enter a university, you have chosen to do law. I'm sure that you asked yourself the question, why am I doing law? What is the connection between law and society? What is the connection between me and the law? What is the connection between law and politics? You may have some tentative answers to these questions, but let these questions stay with you throughout your student years in this university. For one day, you will have to stop asking these questions when you qualify and come up with answers in the decision that you make to enter your chosen career. But for now, these are questions you do need to ask yourself. Today, of course, we all know that law offers options to you, such as policy making, working with think tanks or with the government to determine policy, academics, action-oriented research, legal journalism, apart from the traditional entry into the world of litigation and the world of law firms doing transactional law. So you can see the wide variety of options that are opening up to you once you finish your graduation over here. But you will constantly be asking yourself the question, which one of these do I choose? Now, the answer to that depends on your vision of law. What is your imagination of the law? What is your vision of the law? What I'm going to do is offer you my vision, which I began with and which has stayed with me over the years. I told you it's more than 50 years since I have been in this profession. So here is my vision. I belong to a generation of people who grew up with the legacy of the independence movement. Remember, you are this year entering the 75th year of independence. But imagine a person like me who was born and brought up with the legacy of the Indian national movement and of the independence movement. I stand at a different point of history compared to you. The Constitution was just newly written at a time when I was already born. And the text of the Constitution is an aspirational text. And hence, my generation looked upon the Constitution as fulfilling our own aspirations, our aspirations of liberty, equality, fraternity, and dignity. I believed that the law is an instrument of social change, and I continue to believe that after this many years of practicing law. Even if I say so myself, it's a great achievement because it's possible to get extremely cynical as you proceed down the journey of life in the legal profession, especially when you see what you see around you. You do see attacks on the judiciary, some of them self-inflicted, some of them inflicted by an over-anxious executive. But to retain your own belief in the mission of the law as an instrument of social change is what I believe in and what I have succeeded in doing. And if you really want to know the secret of my success, that's it. It's as simple as straightforward as that. I'm not a cynic. I continue to have what I have titled this talk, A Love of the Law. And I invite you to also have a similar love of the law. I have been often described as a feminist lawyer. Hence, it is important for me to explain what I mean by being a feminist lawyer. I don't necessarily accept this title, but yet it is incumbent upon me to tell you what is my understanding of feminist lawyering. The Indian Constitution itself is as much a culmination of the ideas of the freedom movement against colonial powers as it is of socio-economic religious reform movements of the 19th and 20th centuries. Our Constitution thus not only provided for freedom by ending foreign rule and establishing a democratic republic, it also provided a roadmap to undo deeply entrenched social exclusions and hierarchies of our society. Glanville Austin, of course, has rightly described the India's constitution as a document of social revolution. Others have inspired the vision that the constitution finally took in its march towards social revolution. Now, recognizing that these two parallel movements shaped our constitution, Justice D.Y. Chandrachud, in his separate opinion in Indian Young Lawyers Association, observed thus, and I quote, "Besides the struggle for independence from British rule, there was another struggle going on since centuries, which still continues. The struggle has been for social emancipation. It has been a struggle for the replacement of an unequal social order. It has been a fight for undoing historical injustice and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of these two struggles." I think you should write this down and keep it with you for all the 5 years that you go through law school or your post-graduation, because it tells you very clearly which direction to take, not only in appreciating your own constitution, but also in appreciating your own journey and shaping it. It is this other side of the independence movement that I trace the foundation of my feminist lawyering to, and indeed all my lawyering. And this is the reason why I recognize the intersectorality of rights. I'm not just a woman. I'm not just any woman. I'm, of course, a privileged woman, but I recognize intersectoralities of caste, class, sex, race, and all of them, all of which enter into my lawyering. Reading the equality provisions along with this multifaceted social movement is a strong foundation for constitutional equality can be developed in India, and very, 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 I would say, India-specific foundation. I would like you to know that the Indian Constitution is unique in the world. No other constitution has attempted a social change of this magnitude by constitutional means. This is a unique feature of many post-constitutional colonial constitutions, but India was among one of the first such constitutions, and therefore you are privileged to have this constitution as your primary document to work with. The constitution, of course, was not created only for elites who consider themselves more equal than equal. The constitution was rather a direct answer to the demand for equality by women, by Dalits, by Adivasis, and by many other subaltern groups. In the iconic book, To Kill a Mockingbird, the protagonist lawyer Atticus says as follows: "While unfortunately all men aren't born equal, there is one way in which men are created equal. There is one human institution that makes a pauper equal to a Rockefeller, the stupid man equal to Einstein, and the ignorant man equal to any college president. That institution, gentlemen, is the court. Our courts have their faults, but in this country, our courts are great levelers, and our courts, all men are treated equal. Now, I think this is something that you're going to have to critically analyze. Do we live in a country in which our courts treat all human beings as equal? It's a large subject, which I'm sure you will expound on, but the fact remains that access to courts is also a fundamental right in our constitution, and in our constitution alone. Our constitution enables the leapfrogging of the hierarchy of courts to enter directly into the Supreme Court of India if there is a violation of fundamental rights in Article 32. And it was Dr. Ambedkar who said, this is the heart of the Constitution. I read somewhere recently that over 1,200 PILs are pending in the Supreme Court as of now. What is this an indication of? It's an indication of the fact that the courts have their doors open to anybody who thinks there is a public cause to espouse. This is the ideal, but not necessarily the situation that we find in our courts. Taking decisions, therefore, and what to do with the law fell into place naturally for me, since I took that as my vision. I had no doubt about what kind of law I wanted to do. We read and reread, my generation read and reread the directive principles of state policy, and we wondered what was meant by the expression shall be fundamental in the governance of the country. And it was my generation of lawyers which was responsible for introducing the concept that since directive principles were fundamental in the governance of the country, they should be used as tools to interpret fundamental rights. One of the earliest cases I did was the Olga Tellis case, which was protesting the homelessness of pavement dwellers in Bombay. And we did use the directive principles of state policy to interpret the right to life, which we said was being denied to them because the right to work was being denied to them, and livelihood. I will not trouble you with reading the directive principles, but I would definitely like you to read Article 39, Article 39A, Article 42, and Article 46, which says that the state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular the scheduled castes and the scheduled tribes. I must tell you that a lot of my work revolves around the rights of scheduled castes and scheduled tribes. And right now, on the 10th of August in the Supreme Court, we will be arguing some very fundamental cases relating to the rights of scheduled castes and scheduled tribes to equal and adequate representation in services under the state. I now come to what I mean by the love of the law. What then accounts for my love of the law, apart from what I've said above? We have forgotten that there is a place for emotions in the law. And this is why I want to bring in, concepts like the love of law. I think concepts like this have an emerging role to play in the law. I have been repeatedly told that when we argued the challenge to Section 377, which decriminalized homosexuality, by those who were affected, to say this is about the right to love. Well, whether it was or not, I don't know, but I do know that we all have the right to love. And for me, I do have a certain love of the law. Let me give you the example of two very recent judgments of the Bombay High Court. While granting bail in UAPA cases, as you may know, it's very difficult to get bail because you have to prove that prima facie you're not guilty. But the court evolved a principle of the grant of what they called humanitarian bail. And they said that this is an exception to the rule of regular bail on merits. And in several cases, they have been granting bail on humanitarian grounds, such as, for example, medical treatment, and more recently, permitting people to attend the funeral of their loved ones who are outside jail, which otherwise was being denied to them by the trial courts. There are other examples. One from Delhi, as you know, as you all know, Safora Zakar was granted bail on the ground that she was then pregnant. I presume the theory was, even if the mother is guilty, why should the unborn child have to suffer the guilt of the mother? So let me tell you that you are entering this university at a time which is very challenging. And never forget that words, the law is about words. The law is also a lot about linguistics. But words have a certain magic about them. You can make them say what you want them to say. And I'm not here referring to the Humpty Dumpty of Alice in Wonderland, but it's true. You can put contemporary meaning into the words of the law. And I think a lot of my success has depended on my creative ability to put contemporary meaning into the aspirational text of the law. And as I told you, the Constitution is nothing but an aspirational text. So I would urge you as students to focus a lot on the words and expressions that are used in the text of the law, and then see how you can magically turn them around. If you have a goal in mind, that if you want a certain outcome, check how these words can help you to get to that outcome. I have a million examples, but there's no time for me to give you all that. For that, you'll have to meet me some other time, some other place. So this is the reason I find the law so attractive. It has creative potential. It is a creative pursuit. It's almost an art form as far as I'm concerned. It helps you to imagine a different world which is free from oppression. And as I already told you, the governing text is in the Directive Principles of State Policy. None of these texts have any fixed meaning. And I believe that every generation has a right to approach this constitutional text with their own lived experiences. So these are some of the challenges that you will be dealing with in your 5 years. Of course, I could give you quotation after quotation. Here's one from the US Supreme Court, and I quote, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within the lawful realm to define and express their identity." How do you define your identity? How do you define your identity in the law? How do you define your identity as a lawyer? These are the questions that you're going to be asking yourself. Without such a pursuit, the right to privacy, the right to die with dignity, the right to freedom of sexual orientation, the right to shelter, the right against custodial torture, the right to a speedy trial, and many other such rights would not have seen the light of day. But they have, and you all know it, including the right to die in the Aruna Shanbag case. All these exist because somebody had the imagination to revision Article 21, and I'm sure you can think of a much longer list than me. Now, when you enter a courtroom, let's talk a little bit about entry into a courtroom, since I am primarily a litigating lawyer, and I'm going to tell you a few things which have happened in my real life. So when you enter a courtroom, what is the first thing that you see? The first thing that you see when you enter the High Court, at least the first thing that I see, is that if you keep your eyes at eye level when you're walking into a courtroom, what will you see? You won't see the judges. You will see what is above the head of the judge. And that is in the High Court's Satyameva Jayate. your vision, because you're standing up, and as you enter the courtroom, your vision will be directly on this motto, Satyameva Jayate. And as you enter the Supreme Court through the front gate, what you will see is Yatho Dharme Tatho Jayate, which is a little different from what you will see in the high courts. Now, I don't have the time to tell you what's the difference, but maybe some other time I will tell you the difference. But what I want you to understand is that imagine yourself standing outside court number 1 in the Supreme Court of India, opening the door and walking in. You will see this, the first thing that you see as you enter the courtroom. Even before you see the judges, you'll see this. And I once, I was arguing a very, very important case, and I really don't understand what the provocation for this was, but I felt like being mischievous. So I just said to the judges, I said, you know, my lord, you have a tragedy. There's a tragedy in this courtroom. And that is that when I enter the courtroom through the front door, and this is the first thing I see before I begin any argument in a courtroom, your tragedy is that you enter the courtroom through the back door. And when you enter, you're not able to see what's above your head. So that's the difference between you and me. This is how I explained. It was, as I said, it was an extremely mischievous thing to say, but my point went home. And I was not, fortunately, reprimanded for having said to the judges that you enter through the back door. And then, of course, I recommended to them, why don't you also put this motto right on top of the entrance, so that that's the first thing you see when you enter the courtroom. Now, let's talk a little bit more about what courts are all about. I have said that courts are actually conflict zones. We're accustomed to thinking of conflict zones as war-torn areas, but I have been referring to courts as conflict zones. Any of you who have seen a heated discussion between lawyers in court would reimagine this as a conflict. Central to the role and purpose of the institution is to serve the seeker of justice. No one walks into a courtroom voluntarily. They're all there, either because there is a dispute for which they want relief, they want justice, they have been summoned to court, they are accused persons, they have lost some loved one. There are millions of reasons why. These are the reasons why people enter a courtroom. In either case, courts exist for them, not for lawyers. We serve them. Now, in these conflict zones, we as lawyers try through our efforts to convert these conflicts into resolutions which are just. But the central quest remains the pursuit of justice. Again, there's a long debate on what's the difference between law, what's the difference between law and justice, but take it from me, your gut feeling in any given case will tell you what justice is all about and will lead you to the answers, as I have been led to many, many answers. Let me move on to saying a few words about the rule of law. The rule of law is distinguished from the rule of tyrants and authoritarian leaders. We all know that. But our Supreme Court said it in a single sentence when they said in the Vineet Narayan case, be you ever so low, be you ever so high, the law is above you. So therefore, our task is also to call everyone to account. Now, in our newfound liberty, barely 75 years old, we have fought for and maintained a vigil in the courts as lawyers. Majoritarian governments, we have found, tend to threaten these frameworks of law, justice, and rights and governance. There is a disproportionate presence of poor people in our jails, wrongfully prosecuted. the framing of people from minority communities and marginalized communities. These are all the issues of our times, which you will be called upon to address when you conclude your education in this wonderful institution. I'm going to say to you a few more words about my own role as a lawyer and stop there because I know I'm running behind time. Uh, I think I'll just give you one example of a case which I did recently, and that was the Shabri Malay case. What is specific about this case is two things. You all know that it concerned the right of women to enter a temple, the Shabri Malay temple. They were excluded between the age of 10 to 15. I think the breakthrough which I made in this case, when I told you this is an example of imaginative thinking and an example of how the personal is political, it suddenly occurred to me that what was happening here was menstrual discrimination, and what was happening was untouchability. And we were all accustomed to thinking of untouchability as something that happens to scheduled castes and scheduled tribes. But I said untouchability also happens to menstruating women because they are excluded. And I came upon this understanding because of my personal experience in my own home. I came from a home where untouchability of menstruating women was practiced. In my mother's generation, I had seen my mother being quote unquote put out during the period when she was menstruating. Menstruation was not considered a now normal, natural bodily function, which cleansed your body rather than polluted it, and women were considered polluting. And this is how I argued that this was a form of untouchability, and at least one judge agreed with me on that and said, yes, it was a form of untouchability. But I mentioned this for the two reasons I stated above. First, to explain to you exactly how you can use your imagination and contextualize uh, words of the Constitution, which were supposedly meant for something else. I will now quickly stop by telling you that there is a role for lawyers outside the court as well. In my own journey, I have been a litigating lawyer, I have been a policy maker, I have helped through the Lawyers Collective to draft the Protection of Women from Domestic Violence Act. My colleagues have helped draft the only anti-discrimination law which exists in this country, the law which forbids discrimination based on HIV/AIDS, and the only anti-discrimination law which applies horizontally to the private sector as well. So there is a huge role to play for lawyers even outside the legal profession. And perhaps one can even combine all of this. I have recently started a new website at www.theleaflet.in, and that's an example of how I've been able to combine my journalistic skills along with my litigation skills and along with my policy making skills. Okay, none of this has been done alone. I have a wonderful team of lawyers at the Lawyers Collective, and undoubtedly, without them, none of this would have been possible. I conclude by saying I advise you to guard your own independence. And what does this mean? Independence of thought. What does this mean? It means taking up cases which are unpopular with the general public. We have been criticized for representing Yaqub Memon. We have been called anti-national, but it did not deter us from taking up the cause because we were opposed to death penalty. The issue there was not whether he's guilty or not, but whether the death penalty should be imposed. So I urge you to not succumb to quote unquote the collective conscience of the community and keep your conscience intact and take up unpopular causes if you must. I would strongly urge you as a litigating and a practicing lawyer to keep your independence from the judiciary. It is very common for lawyers to say, yes, my lord, no, my lord, nod your head when a judge nods his head, laugh at his jokes, agree with everything he says, and walk out of the courtroom. That's not what is expected of you. what is expected of you in a courtroom? The ability to say no to a judge. Say it politely, but say it. If you disagree with the proposition that a judge is making, please stand up and say, I disagree. Your intellect carries the same value as the intellect of a judge in the courtroom. And whereas the independence of the judiciary is a well worked out concept in our jurisprudence, independence of lawyers is not well worked out. I'm going to conclude now by reading out to you a stunning statement made by the then AG of the United States of America, Sally Yates. Many of you might have read this, but it bears reading and rereading. And here it is, when she was opposing the Muslim ban imposed by this Trump administration. She refused to implement it in her capacity as Attorney General of United States of America. And this is what she said, I quote, "My responsibility is to ensure that the position of the Department of Justice is not only legally defensible, but is informed by our best view of what the law is after considering all the facts of the case. In addition, I'm responsible for ensuring that the positions we take in the court remain consistent with the institution's solemn obligation to always seek justice and stand for what is right. At present, I am not convinced that the defense of the executive order is consistent with my responsibilities, nor am I convinced that the executive order is lawful. Consequently, for as long as I am the acting Attorney General, the Department of Justice will not present arguments in defense of the executive order unless and until I become convinced that it is appropriate to do so." Really, I cannot give you any more guidance than this. This, for me, is what is meant by the expression constitutional morality, which we hear repeatedly now in our judgments. What is constitutional morality? Constitutional morality is what Sally Yates said. Constitutional morality is not, because I'm the Attorney General of India, I'm going to rubber stamp everything the executive says. No. I have an independence, I have a role which is assigned to me under the Constitution, and I will discharge that role. I'm going to end in the hope that I have provided you with some little guidance on how to undertake this journey through the next 5 years or 2 years, as the case may be, and prepare yourself to enter what your professor called a noble profession. It is a noble profession. Thank you.
Thank you very much, ma'am, for those beautiful insights. We have a few questions with us. So the first question is about what are the challenges that you have faced as a woman lawyer in a male-centric environment, male-centric legal universe, where it's like an all boys club, be it the bar or the bench. So what are the challenges that you faced, and what advice do you want to give to the young students, the next generation of lawyers in such a scenario? And when you raise these issues, social justice issues, women rights issues, how does the judiciary respond? Because it's male-centric. So what are your experiences like?
So 2 questions. The first one is, the challenges of being a woman lawyer continue till this day. So, contrary to my own expectations, when I thought the challenges will have to end one day, I don't think they ever end. I don't think there is an acceptance of women as equal in the legal profession. And as I have said, people say you've broken the glass ceiling, but let me tell you that the glass ceiling doesn't break with one individual breaking it. This is my realization, okay? It only breaks when the entire community of women breaks the glass ceiling. That's when it's broken. So how do I deal with it? I deal with it by trying to make it a better place, not just for me, but for all women. So I'd like to give you 3 examples of what I did to make the place a better place to be. One, I filed a petition in the Supreme Court that there should be a creche where people could bring their children to court. You'll be surprised to know that there was no creche in the Supreme Court of India until 3 years ago. It was only after I filed a petition in court. And again, this petition came to be filed because I had a junior who used to bring her little baby to work, and I would see this baby sitting under the trees in the heat in the Supreme Court with no place to go. And that's when I decided this is not working. I need to file a petition for a creche. And today the Supreme Court of India has a state-of-the-art creche. Any number of women have told me that this has made a big difference to their lives. Women have told me that they would suffer from guilt, keep leaving their children at home and coming to the Supreme Court to work. So that's one way that I dealt with it. The second is I did file a petition in court saying the system of designating senior lawyers should change. And it did change. It became more objective. It became more friendly towards women. And after that petition, a lot more women have been designated senior lawyers. And the third petition which I filed, these things go to infrastructure. The infrastructure of justice is as important as the substance of it, is that I filed a petition saying that there should be live streaming of court proceedings. Today, this is going to become a reality. So I think one way to deal with it is to keep your eyes and ears open in a courtroom and to try and decide for yourself how to make your environment a better place to work in, so that you get the equality of opportunity that you're looking for. On your second question, how do judges react to social justice issues? Look, it's a bit of a difficult question to answer, because the honest answer is that they react well. But the question is, a lot of this for judges is really low-hanging fruit. It's not difficult for a judge to say, let's look at equality for women, and let's agree that there has to be equality for women, okay? Because it's not a hard issue to decide. So there are issues of social justice which are well addressed by the courts, and there are issues of social justice which are not well addressed by the court. And I would say there is an overlap between issues of social justice and political justice. And when you get that overlap, your challenges are much more, because you sometimes directly enter the realm of politics. Your social justice issues really become a political issue. So whether it would be things like, whether Aadhaar should be mandatory, it becomes a very political issue. It's also a social justice issue. So judges do address certain types of social issues very well, other types of social justice issues not so well. There you will need more strategizing when you're dealing with issues like that.
Right. Thank you, ma'am. There are a few other questions. So the other question they've asked is that, what is the reason why you chose litigation as a profession? Because most of the students come from national schools, they choose corporate lawyering. That's the first. And the second is that, what was your idea behind starting the Lawyers Collective?
Okay. Let me take the second question first, because it takes me back to the 1980s. I would like you to recall that the provision for legal aid in the Constitution of India was added in the year 1985, 39A, Article 39A. And until then, there was no concept of legal aid being a right. So, and Lawyers Collective was started before that provision was added in the Constitution of India. So the idea behind the Lawyers Collective was to do pro bono work for marginalized sections of society. We actually started with working with employed workers, and actually started even before that, representing the railway workers who were dismissed during the emergency in 1975. And from there, it kept evolving and evolving until it changed, because after 1985, you had the right to legal aid as a fundamental, as a right in the Constitution. Then it took a long time for this to get actualized when the Legal Services Authority Act was brought into force. It was much, much later. It was lying on the statute books. And I remember Lawyers Collective had to file a petition to bring that act into force. Then the authorities were set up, and then the schemes were set up under that. And then you find that a lot of the work that the Lawyers Collective was doing also started getting done by the Legal Services Authorities, and it also started getting done by a lot of NGOs. But what you need to recall is it was the first which said this is a blank in the Indian landscape of justice, and it needs to be filled up, and it needs to be filled up by lawyers. There were many other impulses that went behind it. And then, of course, we got into policy. I told you we started drafting laws. That too now is happening quite generally. You've had laws like the RTI, you've had laws like the NREGA, which have been initiated by people's movements. And the other question was, why litigation? Now, how can I give you the answer to that? I just suppose that the coming alive of law happens inside a courtroom. There is no substitute for the thrill that you feel when you hit upon an argument which you feel has transcended the controversy which is before you. And you stand in a courtroom and you say, hey man, I know the answer to that. I know the answer to that. Just give me an opportunity to tell you what the answer is. It's very, very thrilling. And I mean, to be honest, that is the reason why I chose to be a litigating lawyer. I'm not going to say you can contribute more. You can contribute anywhere you want to contribute. But take it from me, there's no substitute for that thrill. And as for people wanting to join corporate law firms, you will be surprised if I tell you that a lot of my juniors who joined me came from this very university with the intention of being corporate lawyers. And they were corporate lawyers for the first 2 years of their life. They suffered from intense burnout, and they suffered from intense boredom. And they gave up their corporate law practice and they came and joined me. So, and they are today, today maybe more successful than I am as litigating lawyers. So I hope I've answered your question, but at the end of the day, it's your choice.
Right. A lot of other questions, two more maybe. One is, what is the importance of building grassroots level associations and long-lasting, long-term relationships outside of law, especially when it comes to social justice lawyering? That's the first. And the next one was, a lot of students have raised this, and that's also my question is, what is your idea of restorative justice, especially when you wanted Jyoti Singh's mother, Nirbhaya's mother, to, forgive her perpetrators? So that's these two questions.
Okay, so the first question first, on the necessity for links. Okay, yeah, I'll tell you something. I don't believe in filing public interest litigation just because it is public interest litigation, right? I believe that the felt need for that litigation must come from the community. And this is the reason for building those long-term relationships, okay? You can go and file a petition in court as a PIL, and the courts will entertain it without any forward and backward linkages, okay? The judgment will not be worth the paper it's written on. It is only when you are linked with, shall I say, the affected community, okay? I must tell you that as a lawyer or as a litigant, you cannot substitute for the affected community. You cannot substitute yourself for the affected community. That would be a big mistake. That would be like a nice ego massage for you, but it's not going to get you the justice that you're looking for. It is the affected community who will be in a position to tell you where the social justice lies. And this ties into your second question of restorative justice also. So what is restorative justice? Many people think it is the right to compensation. Now, I'm struggling with that issue. In the case of the death of Stan Swami, what would be restorative justice in that context? Think about it. I think there are two ways in which I would visualize restorative justice. One is an acknowledgement of the failure of the system, which led to the death of a person concerned, is what restorative justice would mean for me. Secondly, a public apology. And thirdly, the guarantee and the assurance that it will not happen again. Then you can add to that if you want, compensation. But from my experience, I can tell you that many of my clients tell me upfront that they don't want compensation. I sometimes, struggle and fight with them and tell them, do claim it. And let me tell you, many women who face sexual harassment tell me that they don't want compensation. They tell me, ma'am, if we claim compensation, then people will say, oh, she's a gold digger, and oh, that's all she wanted, and all she wanted was money. Look, I don't agree with the way they articulate it, but they are the client, so I can't force my views on them. Okay, there are situations in which I think compensation can also be part of restorative justice. And very often I tell them, listen, what you do with the money is your lookout. You may donate it, you may give it. But sometimes penal damages can be a deterrent for recalcitrant employers. So I think to answer your question of restorative justice, it would vary from situation to situation, but I think I've given you some indication of what it means to me, what would make me feel that my labor has been worth it.
We'll take one last question because we're almost at 4. The other question that students have been asking is that over a period of time, when you said that the idea of social justice and social change and this aspirational reading of the Constitution as a student, but over a period of time from your days as a college student till now, how do you think this idea has changed? Let's say the aspirational reading or the emotional reading or the idea, the concept of social justice over a period of time?
That it has changed, there is no doubt. I think the general change has been towards individuation, and where, we often forget that fundamental rights are granted to whom? To individuals, okay? And what happens is that we are a society which very much see ourselves in units. Maybe all societies do. For example, the rights are in the unit of the family and not the individual, or the rights are in society and not the individual. But I think what has changed over these last 75 years is a greater recognition of the individual as an autonomous bearer of fundamental rights, rather than as a person who has only obligations towards a family unit or towards a given social unit. I mean, all these questions came up when we deal with issues like personal laws, which I have not had time to go into because I work a lot on personal laws. A lot of this came up in the triple talaq case and cases like that. It evolves, but the basic evolution over the last 75 years has been an evolution towards recognizing the autonomy of you and me as individuals and our aspirations, and being given the opportunities to fulfill our aspirations and defining our futures for ourselves.
Right. Ma'am, there's a question from a student that's quite interesting. She says, why didn't you choose to be a judge? you could have made immense changes. Why didn't you do that? That's a question, yeah.
I can't answer this question except to say I love a good fight. And I wouldn't be able to do that. I would be under too many, restrictions. Oh, behave yourself, or don't say this, don't say that, be like this, be like that. So now at least I have my own autonomy. But you can make a difference anywhere. Don't take my advice. Do become a judge. A lot of my juniors have become judges, and they're doing fabulous work.
Right. Thank you for those insights, ma'am. And we've come to the end of the discussion. I would like to thank you for taking out time to interact with our students. My heartfelt gratitude. We look forward to having more of such interactions with you in the future. Thank you very much. I would also like to thank the registrar, my colleagues, and our lovely students for being the audience today. I would also request the registrar to maybe say a few words. Is he, yeah. Okay, I think he has logged out. Okay, so thank you very much, ma'am. Thank you. Thank you so much.
Thank you.
See you all tomorrow for the, yes.
Thank you for inviting me.
Have a good day.
Bye.
Thank you, ma'am. Bye-bye.
Bye.